Hi there, I'm Charles Shen, partner of Shanghai Puruo Law Firm. Today, I would like to talk about how foreign invested enterprises (FIEs) to dismiss employees and make staff redundant in China. In case foreign invested enterprises decided to contract or even shut down their business in China due to various reasons, inevitably, they have to consider how to dismiss employees and make staff redundant legitimately and economically. I would like to discuss briefly some legal options available according to Chinese labor law and regulations. 1. Dismissing the staff through friendly negotiation. FIEs may propose and terminate the employment contract with the employee through friendly negotiation in case the termination agreement is concluded. FIEs, the employer, should pay the employee severance pay based on the number of years worked with the employer at the rate of 1 month wage for each 4 years worked. Any period of less than 6 months but less than 1 year shall be counted as 1 year. The severance pay payable to an employee for any period of less than 6 months shall be 1/2 of his monthly wages. The same below. Obviously, it could be reasonably anticipated that it is much time-consuming and difficult to terminate the employment contracts with the employer through friendly negotiation. 2. Dismissing the staff when the employment contracts expire. FIEs may refuse to renew the employment contract when its term expires. While FIEs should pay the employee severance pay based on the number of years worked with the employer at the rate of 1 month wage for each 4 year worked. However, please note that the employment contracts with the employees who have worked for FIEs more than 10 years will never expire. C. 3. Dismissing the staff by unilaterally rescinding the employment contracts. In accordance with Chinese labor law, only with legitimate reasons can an employer unilaterally rescind the employment contract. Otherwise, the employer should pay damages to the employee at twice the rate on the severance pay, i.e., based on the number of years worked with the employer at the rate of 2 months wage for each 4 year worked. Generally speaking, it's far from easy for FIEs to argue any legal grounds which justify the unilateral rescission. 4. Dismissing the staff by making staff redundant. Article 41 of Labor Contract Law of the People's Republic of China states, if any of the following circumstances makes it necessary to reduce the workforce by 20% or more, or by a number of persons that is less than 20 but accounts for 10% or more of the total number of the enterprise employees, the employer may reduce the workforce after it has explained the circumstances to its trade union to or employees 30 days in advance, has considered the opinions of the trade union or the employees, and have subsequently reported to the workforce reduction plan to the Labor Administration Department. Restructuring pursuant to the enterprise bankruptcy law. Serious difficulties in production and or business operations. The enterprise switches production to introduce a major technological innovation or revises its business method, and after amendment of employment contracts still needs to reduce its workforce, or another major change in the objective economic circumstances relied upon at the time of conclusion of the employment contracts, rendering them unperformable. FIEs could make staff redundant by reason of another major change in the objective economic circumstances relied upon at the time of conclusion of the employment contracts, rendering them unperformable. Section 4. However, the redundancy procedure is much complex and time-consuming. In addition, FIEs should pay the employee severance pay based on the number of years worked with the employer at the rate of 1 month wage for each 4 years worked. 5. Dismissing staff by reason of company dissolution and liquidation. According to Article 44 of Labor Contract Law of China, an employment contract shall be terminated if 5. The employer has its business license revoked, is ordered to close, or is closed down, or employer decides on only dissolution. The shareholder of FIEs may make a resolution to dissolve and liquidate the company incorporated in China. Logically, all the staff has to be dismissed during the dissolution and liquidation process, while FIEs should pay the employee severance pay based on the number of years worked with the employer at the rate of 1 month's wage for each 4 years worked. Thank you for watching.